Hello, this vid is on the inherent problem of written constitutions and political conventions and steering groups and the friction between those three um, forces in the law, in economics, in governance. Now, to this cover written constitutions, well, we can argue that written constitutions actually did come from um, political or social or cultural conventions and also steering groups. The often cited use of the US Constitution is that the US Constitution is the law, and therefore the country should be run on that Constitution. Now, the US Constitution is very easy to read, and anyone can pick it up and read it. I can read the US Constitution in about an hour. If you wanted to use it for reference, you could pick out a particular amendment to help your case. But the US Constitution came from both some revolutionary changes and from the English common law. Now, the English common law is from Anglo-Saxon or Germanic law. Okay, now this is actually a cultural conventions in certain parts of the different Germanic or the different Nordic countries, okay, and the Celtic countries. The different nations had particular common laws to themselves. These were then eventually written down. One of the main ones would be by Alfred the Great, and Offa, and also in with the Frankish kingdoms of Germany and what was the Frankish Empire, in what is now modern France, would be the Charlemagne's law codes. Okay, the other the Saxon law codes in Saxony in Germany as well, and also the Scandinavians developed their own codes during the Viking periods, which is say respect for women, that women could divorce their husbands simply by having a witness. The witness there thus became more and more important for the conduct of law and customs, because we can say now that a lawyer, although they're not present at the time that a crime or a civil act of disobedience or a civil wrong can that occurs, such as say defamation of character, although they are not there at the time, they are a professional witness because they understand the law. Now, it used to be that most people during the Middle Ages would understand the law. In fact, the Norman conquest faltered at this point because the English people used the law courts as a form of resistance, because they said, no, this arbitrary power that you have because you have more swords than us, or you have the army to impose your will on us, is not actually the law. So it's that same use of soft power that I've described between the US and the EU. Or the US will try to use military power. Now, I'm not comparing the US to the Normans. That's two completely different separate ideas. Okay, what I'm talking about is that, for instance, we have political conventions and cultural conventions at work. For instance, those then become law. For instance, if you are not a vegetarian and you like to eat beef, it's not illegal for you in England to eat a steak, right, of beef, but it is in India because Hindus believe that that cows are sacred. But Muslims in India who live there eat cows, and it's a political convention that they're not persecuted for that law because of their religious belief. That is a way that the two different cultures have come to an agreement. Okay. Now I'm going to be doing an more parts to this series of talks on political conventions and constitutions, but let's deal with the US Constitution. The US Constitution came out of English common law. Those common laws were then put down and written down into statute through precedents that were set in cases. Then certain revolutions happened. The revolution of the Glorious Revolution, which incorporated England into the Dutch Empire under William of Orange, although William of Orange was a prince of Holland, right? He became king of Britain, okay, or mostly his focus was on England, but of Britain, okay. That introduced that finalised the long process of the Protestant movement that started with Luther, of changing the official language of the intelligentsia of governance from Latin into English, because of course during King James's time the Bible was then written in English, right, as the official language of the Bible was then English. This is very important because in addition to both Roman statute law, which is where we get the Latin from, and English common law, which is of course comes from the Anglo-Saxons, and the deeper Germanic law that goes way back to time immemorial, the Bible was used because that they believed in the past to be the direct word of God, and this is a problem the West has between Jewish and Islamic identities, because though both Jews and Islamic people or Muslims believe that the Bible is the direct word of God if they're religious and practicing. So in a sense the Bible is the statute law of God in their view, okay, or the Quran or the Torah, which are forms of the Bible. Okay, now but is that really statute law? Because it doesn't really come from our culture, and it isn't based on on court law that has been set by precedent. It's merely a political convention that we refer to the Bible, or that we place our hand on the Bible and swear an oath to uphold the law. Really, this is where also the political convention, which binds the courts to the monarchy, and the whole fusing of the powers in our system, which is completely different to the US Constitution. The fusing of the executive, because the executive owes its allegiance to the Queen, and the Queen is the head of the Church of England, and the Church of England speaks as the mouthpiece of a god or some such thing. So therefore our law is still quite affected by this Christian legacy. And there's an argument because the original US Constitution didn't have under God, it merely had under the law. Okay, now I'm going to, which of course in the UK system is wholly ingrained into with the Christian identity, and thus goes back to the rabbinic laws of Israel as well. But we also have common law, and we also have the Romans who invented statute law. Okay, now I'm going to do a part 2 on this. See you then.